It is August 17th of 2026, and this is the Court Gallery. First, we head to Judge Ricke's courtroom, where a defendant blames his failure to appear on being stranded in Hawaii, while another blames his missing phone. Judge Ricke thinks both of them have far too much of a reliance on modern technology. Next, we journey to Judge Middleton for a mind-bending stalking case where the alleged victim simply cannot stop texting her abuser and professing her love for him. Judge Middleton is not happy. Finally, Judge Buckley handles a bitter neighborhood feud over boomboxes and stray cats, topped off by a petitioner threatening to unleash the FBI on the Olympia court system. That's right, Miss Donahue is back. All that and more starts right now.
Kanai Akana?
Yes.
This is the State of Kansas versus Kanai Allen Akana. It's case number 2026 CR 27. Defendant appears at the jail Zoom location. Joseph Bach on behalf of the state. Mr. Akana, I see disturbingly on this docket sheet an order of bond forfeiture bench warrant due to the defendant's failure to appear back on June the 12th in Judge Satterfield's court. No bond hold was ordered. Makes me wonder, Mr. Akana, why didn't you appear for Judge Satterfield's court when you were supposed to?
I didn't have a ride. I'm from Hawaii, and I live in Wichita, and I didn't have a ride. I mean, that's all.
What's the pertinence of you being from Hawaii? What difference does that make?
That I have no family here.
Wichita's not that far. You're supposed to find a ride.
I'm not making no excuses. That's why I didn't show up.
All right.
But
okay, it looks like sentencing was the proceeding you didn't show up for. So I don't have any date otherwise on Judge Satterfield's calendar, but I can assign September the 21st at 2:30. September 21, 2:30 p.m. is reset as the next appearance date before Judge Satterfield, ostensibly for the sentencing that didn't take place when the defendant failed to appear. Obviously, the defendant is ordered to appear at that time if for the sentencing in the case. Mr. Akana, I'm insecure about letting you back out. If
Come
you can't
on.
find a ride from Wichita.
Please give me one more chance. Come on.
Okay. Judge Satterfield made the order. It's a no bond hold order. So that right now you don't have a bond. You messed up your bond by not showing up in court. Okay. Judge Satterfield can make a different order. I'm not inclined to.
All right.
For now, you're going to stay in jail. You can work through your attorney. You still have Mr. Watts. He remains your attorney. You can work through Mr. Watts and perhaps have Judge Satterfield review her prior order. But I think Judge Satterfield is going to have to release this no bond hold order. Okay?
All right.
We got a court date. Mr. Watts remains his counsel. Excuse me. Defendant remains on no bond hold.
Thank you.
All right, the next case on my docket involves a Dewan Bird.
Yes, sir.
Okay. This is in the matter of Dewan Bird, case number 2026 JV 22. Joseph Baca appears for the state. Mr. Byrd from the jail Zoom location. Docket notes indicate, Mr. Byrd, that you had a hearing set before Judge Lee.
Yes, sir.
Showed that you failed to appear. So Judge Lee entered an order for no bond hold until seen by a judge. How old are you right now, Mr. Byrd?
I'm 18 years old, sir.
Okay. You need to show up for court when you're supposed to, Mr. Byrd.
Yes, sir. Do I need to explain the why what happened or no?
What happened?
I lost my phone, and then I got another phone, and then I was calling. I lost access to my email, and then I was calling my lawyer, and she wasn't answering my calls or text messages, and didn't send me the link. So I never ended up getting that link to the Zoom meeting. But I was up in time, sir.
Sounds like a problem with over-reliance on technology, Mr. Byrd.
Yes, sir.
You're fortunate in this regard, Mr. Byrd. I have a relatively quick court date to reassign here. August the 20th at 9:00 a.m. That's just
Yes,
right around the corner. I'm going to go ahead and leave your no bond hold order in effect pending further proceedings. And I presume this is before Judge Lee, this date. Mandy, can you verify that?
That is correct, Judge.
Okay. August 20, 9:00, Judge Lee's court is the defendant's next court date.
Yes, sir.
Is Stephanie Hughes your lawyer?
Yes, sir. It should be.
Okay. Well, then Stephanie Hughes remains as the defendant's lawyer pending further proceedings in this case. August 20, 9:00 for further court. No bond hold remains.
Yes,
Anything
sir.
else at this time, Mr. Baca, from your office?
Nothing from the state, Your Honor.
Mr. Byrd, I just want to make a point here. For many defendants that are in court on a no bond hold order, they're sometimes waiting 4, 6, or 8 weeks for their next hearing. Yours is in 3 days.
It's
So
in 3 days.
reflect over the next 3 days how important it is to appear in court when you're scheduled to do so. Okay?
Yes, sir. I will.
All right.
All right.
The
Thank you, sir.
third matter is in recess at this time.
All right. Thank you, sir.
Hi, Judge.
Wade Wagner?
Yes, sir.
Okay. This is State of Kansas versus Wade Patrick Wagner. It's case number 2026 CR 196. Joseph Baca appears for the state of Kansas. Wade Wagner now appears at the Butler County Detention Facility in El Dorado, Kansas. Mr. Wagner, this court's own docket notes from August the 12th, 2026 indicates as follows. Ms. Norris appeared for the state. Mr. Watts is defense counsel. At 11:07, the court ordered bond forfeiture, bench warrant, no bond hold due to your, Mr. Wagner's, failure to appear. 5 state witnesses were present, available to testify at that hearing, and essentially were sent away without testifying because of your lack of appearance. Court's docket notes also indicate that an evidentiary prelim can be rescheduled once you're taken into custody.
Yes, Your Honor. I just had my court dates messed up. I'm so sorry. I really didn't mean to miss court that day. I even contacted my bondsman and my attorney and said, when do I need to turn myself in? Because I'm not trying to make any more problems for myself. I just had my court dates messed up, and I really apologize for that.
Well, you made big problems for yourself by not showing up for an evidentiary hearing. Wasted a lot of good people's time.
I understand that.
Can't
I'm
keep
very
your court
sorry.
dates straight. Now, it was a step in the right direction, Mr. Wagner, that you turned yourself in and you didn't make law enforcement chase you down.
Yeah, like I said, I contacted my. Go ahead. I'm sorry, Your Honor. I was going to say I contacted my bondsman and asked him when I needed to turn myself in, and he's like, "Well, there's not a warrant issued yet." I was like, "Well, that doesn't mean anything. Can I still go turn myself in, or what?"
So when did you turn yourself in?
That was last Thursday, because I missed court last Wednesday, right?
You missed on the 12th, yes.
Yeah.
Well, I don't have Mr. Watts here. It's going to be difficult to reschedule an evidentiary hearing without having your attorney present on this meeting.
Yeah. Your Honor, is there any way I can get a bond reinstatement so I don't miss any more days of work? I don't want to lose the job I have. I really don't. And I know it's a burden on the court. I honestly did not mean to miss court. Honest to God, I didn't. I just had my court dates mixed up because I have court and municipal court also. And I just don't want to lose the job I have right now out there. I work in Wichita for Superior Rents. If I could get my bond reinstated, even be put on ankle monitor or anything. I just don't want to lose my job I have.
Is it possible that you already have, Mr. Wagner?
I don't think so. I don't think I have, no.
You know, there's a problem right there that you communicate, that you've got so many court dates, you can't keep your dates straight. So you don't have just a criminal case pending in the Butler County District Court. Apparently, you've got some sort of criminal action pending in municipal court.
It's
Get your
not
court dates confused.
It's not a new case though in municipal court. It's an old one.
Then take care of it.
I am. I have
That's
court today.
likely to get your court dates mixed up. What's the state's position here, Mr. Baca?
Well, Your Honor, it does look like originally we had a $7,500 bond. I'm not even sure if the bondsman would want to be reinstated. He's not here to say so, but what I can inform the court is, or in that original bond, a big reason it was set, besides the level 7 aggravated battery charge and the worry about community safety, I see at least 5+ failure to appears on prior cases. He has at least 2 felony convictions along with quite a few misdemeanor convictions on his record. So I have concerns in both areas, not only for community safety, but also future appearance. I would oppose a bond reinstatement today. If the court wants to hear from the state on a possibly new recommended bond amount, I can give that.
Your Honor, I did talk to my bondsman. He said he would reinstate my bond if you would reinstate it for me. I've been keeping in contact with my bondsman and my attorney on this whole time.
Who's your bondsman?
Don Kirkman.
Who's your attorney?
James Watts.
Well, I think those are probably correct answers.
If the court would give me an opportunity, Your Honor, I won't let you down. I promise. I'm really trying to turn my life around. I'm really not trying to be in trouble anymore. I just want to work and have a normal life. And I know I've had past stuff in the past that's been bad and doesn't look good on my record. I understand that, but I really am trying to do better. I really am, Your Honor. I really am. And that's why that's why I wanted to come and turn myself in, because I don't want to be running from the cops anymore. I've done enough of that in the past. I don't want to do any of that anymore.
Mr. Baca, you had an additional recommendation?
Your Honor, if the court, while we would oppose a reinstatement, if the court is looking to set something besides the current no bond hold, state would recommend at least a $15,000 cash or surety bond, also a no contact order with the victim.
All right. The existing bond already has a no contact restriction with the alleged victim initials BK. You know who I'm talking about, don't you, Mr. Wagner?
Yes, Your Honor.
Okay. So obviously any bond in your case is going to have that restriction, and the court will iterate that at this time. All right. Where do you live, Mr. Wagner?
1140 South Topeka, El Dorado, Kansas. It's been my address for the last 4 years, 5 years.
I do wonder why you have such a poor record regarding appearance in court. I think Mr. Baca has every reason to be concerned, as does this court, that you get court dates set, you get out in the community, you forget all about court, and then you just don't show up.
Well, I'm not trying to forget about court anymore, though, Your Honor. I promise you that.
This is unusual for this court, but Mr. Wagner, I think that your prompt communication with your attorney after you failed to appear, furthermore, you turned yourself in, does indicate to this court that perhaps more than some others, you do intend to take care of this matter ultimately.
Yes,
Should the jail be able to verify that Mr. Kirkman will stay on his bond, I'll reinstate it. But with this understanding, Mr. Wagner,
yes, sir.
I'm going to conduct a docket like this again on Friday. I'm going to have you appear at the Butler County Judicial Center in El Dorado. You know where that is? It's the courthouse building.
Yes, Your Honor. I'll be there. I'll be there.
No remote Zoom. You're gonna participate from this very building.
Sure, definitely. I'll log out.
1:30. Be there a little early. 1:30 on Friday. At that time, we'll contact Mr. Watt's office and see if he or a representative from his office can be on the meeting so that we can reschedule your preliminary hearing or otherwise do business on your case.
Okay.
So this Friday.
Yeah, I'll be there.
That date would be the 21st.
I believe so, yeah.
Friday at 1:30 with you at the Butler County Judicial Center in El Dorado. No, I'm not releasing you from any other holds that you have on you.
Okay.
But as far as this case, as long as the jail can verify that Mr. Kirkman will indeed stay on the bond.
Yeah, he said he would, yes.
Okay, well, I think the jail needs to hear it from him.
Okay, yeah.
Okay, and I know they have his phone number, so they can check with him. If not, your bond would have to be reestablished in the amount of $7,500. Okay?
Yes, Your Honor.
Okay.
Thank you.
You just better show up, and I better see you on this docket on Friday.
You will, Your Honor, I promise. I will not let you down.
Well, I've been promised that so many times, Mr. Wagner.
I'm sure you have, but you'll see me there. I swear to God, you'll see me there. Okay, you will.
Okay, well,
thank you so much, Judge. Thank you so very much,
Mr. Wagner. Then we'll see you Friday at 1:30 on this dock.
Yes.
Okay.
Thank you.
All right.
Good morning, Mr. Barber.
Good morning, Mr. Middleton.
We've got several things we need to address here this morning. You were scheduled for sentence in file number 252690. That is a charge of indecent exposure. Your attorney, Rhonda Ives, is here with me, and so is prosecutor Abby Stoll and probation agent Daniel Frazine. You pled guilty in that case, and I ordered a pre-sentence investigation report. And then we lost track of you. We issued a bond forfeiture. The plea was actually entered, a no contest plea on July 2nd. I had requested a pre-sentence investigation report because I wanted to really get to the bottom of what was going on. And in the meantime, you got charged again. You have a new charge of indecent exposure as a sexually delinquent person and a charge of no insurance. I learned this morning about 9 o'clock that you'd gotten arrested over the weekend. I guess I didn't catch it when I looked at the jail roster. How did you come to get arrested this weekend?
You said, how do I come?
Yeah, where and when did you get arrested?
They arrested me in, I don't even remember, but it was, oh man, where was I? I was in Bryan.
Where were you?
In Bryan.
Brighton?
No, Bryan.
What day was that?
It was July 25th. I've been in jail since July 24th.
And where was that?
In Bryan.
I'm not understanding him either.
Your Honor, I believe he was arrested in Ohio.
Oh, you were arrested in Ohio?
Yeah.
Okay.
See, is he saying Bryan, Ohio? Is that correct?
Yeah.
Oh. Did you get a new charge in Ohio?
No, I think the charge was out here, but they had put a warrant on me. They have supposedly did the same thing they did at the Walmart. They had said I committed a use exposure.
All right, well, okay. Well, don't say more about it. I'm going to revoke your bond in this case.
And Your Honor, I do have an update on the insurance case because I think that could be resolved today.
All right, well, let me finish this case.
Okay.
I would still like to at least get some pre-sentence information about what is what. And I'm gonna reset this sentence for a little bit out. Today is the 17th of August. Besides, it's sometimes hard to schedule. I'm gonna set this for 10:30 on September 14th. Rhonda, does that work for your calendar?
No, it does not. I will not make it here in time on the 14th. I've got circuit court matters. All
right.
I'm here on the 15th, at 10:30 a.m.
What do you have that day?
Good question. I'm not sure really exactly where I am either.
All right, I'm gonna set it for Tuesday, September 15th. That's not a usual time. We'll set it at 11. We should be able to do it. Now, there's also a warrant for your arrest in a charge of indecent exposure by a sexually delinquent person. I think that's what you got extradited from Ohio on. So let's take a look at that.
I don't never give them all the information.
1320. In that matter, it is alleged that on July 6th, which was just a couple of days after you entered this plea, that you were a sexually delinquent person and you had done something.
Allegedly.
That says indecent exposure, sexually delinquent person. Defendant was a person whose behavior was characterized by repetitive or compulsive acts. It is alleged in the affidavit that you exposed yourself to someone at the Sturgis Library on July 6th. And the prosecutor charged it as a felony. It's a very odd and possibly unconstitutional felony. It's punishable by 1 day to life in prison. I'm not aware of any other such offense, but it's serious consequences. So in that case, 261320 FY, I'll show a plea of not guilty. We'll appoint an attorney, set pre-exam conference for next Tuesday. That would be August 25th. And a preliminary examination for September 1st. at 1. Now I need to do a bond in that case. I was very concerned that this happened very shortly after this case. I let you out of jail, and within a very short time, this happened. So I'm gonna set the bond here in the amount of $10,000 cash or surety. As it is, I canceled your. Yes, sir?
I said, why is it I don't never get no 10% bond?
Well, it's a cash or, as it is, I canceled your bond in your other case, so you aren't gonna go anywhere. But you are to appear for any hearing or further examination, abide by any judgment entered by this court. Do not leave the state of Michigan. I don't know what you were doing in Ohio, but you're not allowed to leave the state of Michigan. Do not commit any crime while released. Provide information and contact. Do not use alcohol or any controlled substance. No firearms. No assaultive or threatening behavior. Comply with any and all mental health orders. Also, we have a traffic case where there was a warrant for your arrest, no insurance. It's alleged in file 26965SM that you were driving a vehicle here in St. Joseph County on May 14th without having insurance. That case is also full of you failing to appear. I kind of got the case back on track after we entered your no contest plea, but you were supposed to appear in front of Judge Pattison on July 17th. You did not appear, and he issued a bench warrant for your arrest. I don't know if you were already in Ohio at that time or what. Attorney Ives says she has some information about that case. And Ms. Ives, what can you tell us?
Yes, Your Honor, thank you. I understand we had this matter scheduled, I believe it was for July 17th, when Mr. Barber did not appear. When I consulted with Mr. Barber prior to that in jail, he had indicated that he had insurance. And when he got out, he said he was going to send it to me. He did not do that. And then we ended up, he didn't appear on the 17th. And then I understand this whole issue about him being incarcerated, which is probably why I have not been able to reach him. But in talking with this matter with the prosecutor's office, they are willing to give him the no proof of insurance in the vehicle and dismiss the original charge. And I think that would be a very good outcome for Mr. Barber, since he didn't really have the insurance in the vehicle. And he could resolve this matter today if he's willing to do that.
Let's explain that further, Mr. Barber. No insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500, not less than $200. Prosecutor Stoll has agreed to dismiss that charge if you plead to a lesser charge of no proof of insurance. That's not even a crime. That is a civil infraction. Carries a $150 fine. And right now you don't have ability to pay the fine, but it will resolve the no insurance case, turn it from a misdemeanor into a civil infraction. Are you willing to acknowledge that on that date, which was?
I believe the date was May 14th.
Yes.
Of 2026.
That you were driving a vehicle without any valid insurance?
Or at least he had no proof of the insurance in the
Excuse me,
vehicle.
no proof of insurance in the vehicle. Do you accept that, Mr. Barber?
Yeah, I accept that.
All right, that's not a crime, so I don't need to go through your full advice of rights. Ms. Stoll, you confirm the plea offer.
That's correct, Your Honor.
I need to see that
My
video.
cost is 150, and that is due
Mm.
9/17/26. All right, let's recap. I asked for a pre-sentence investigation report to try to figure out your psychological issues and what to do with an appropriate sentence in this matter. You didn't show up. You went off the radar, and then you got arrested in Ohio. I would still like to have Mr. Frazine come and meet with you and get some information to try to figure out what the charge should be. To further complicate things, you have a new felony case with sexually delinquent person and an indecent exposure. It's got very serious consequences. I don't want you to get out right now. I don't want you to go to another state. I don't want you to get in more trouble. I don't want you to certainly cause any more disturbance in the community. So there's a public safety factor of this. Within just days of when I took your plea, you were accused of doing the same thing. Then you left the state and got arrested in Ohio, and we'll find out more about that. Then your actual next earliest court appearance is next Tuesday, August 25th at 8:30 for a pre-exam conference on the new charge. Try to coordinate all this. And your traffic case of no insurance has been turned into a civil infraction. I fined you $150 that you don't presently have the ability to pay. In theory, that's due by September 17th. Do you have any questions?
Nope.
All right, your lawyer will be coming out to see you at the jail. Thank you. We're going to address the matters of People versus Angela Louise Lowry. File number 26824FY resulted in a conviction of attempted resisting obstructing a police officer. That occurred on April 3rd, 2026, May 3rd, 2026. Also, later that same day, May 3rd, she destroyed some property inside of a police car. She was charged malicious destruction of police or fire property or property less than 1,000 but more than 200. That's a misdemeanor. Then on June 14th, there was another resisting obstructing a police officer. At the time they tried to arrest her. And so that also resulted in a conviction for attempting to resist obstruct the police officer. I don't want to leave out the case that was dismissed as part of this plea agreement. Defendant was charged with malicious use of a telephone for a pattern of making threatening, harassing phone calls to an employee at one of the schools at Three Rivers. It went on for months, from October to February. At any rate, that matter was resolved with a dismissal as a part of a plea on these three assaultive offenses. The defendant did not have much in the way of a criminal history, but all four of these were outrageous. We had discussed a competency evaluation early in the process, which would have entailed the defendant being in custody for probably a year while we waited for a date for the competency evaluation, had the evaluation, got the report. I think we determined the defendant was competent, understanding the nature of the proceedings presently. Question was, what was their state of mind at the time all this was going on? So having said all that, Ms. Harden, we've got all three of these cases we need to address. This certainly was appropriate for a pre-sentence report, and Mr. Huff has done an excellent job at that. What would you like us to know?
Thank you, Your Honor. Not much to add to Mr. Huff's report. He does touch on kind of everything that was going on in Ms. Lawry's life around the incidents that occurred. They all did happen fairly close in time. As I did indicate on record at prior hearings, there is currently an MI case open that Ms. Lawfrey is now complying with. She does have a representative from Pivotal with her here today as a support person. And it sounds like things are on the right track. She's complying with mental health treatment, any medication that they have prescribed her, and she's just doing very well. As Mr. Hub indicated, there was a period of time upon her release where she was sent to Beacon and Battle Creek for some additional mental health evaluation and treatment. She was released. She called me while she was there. She called my office when she got out, and we've been communicating via email. So I think the recommendation is appropriate. It does take into account that this is more of a mental health case than anything and what was going on at the time. She does not have a significant record, and she is complying with all terms of bond and that MI case. And again, her representative from Pivotal is here with her today. I think the recommendation is appropriate. I would ask that the officer have the ability to request early discharge if things continue to go well. The recommendation is for a year. However, with her lack of history and her compliance with treatment, if Mr. Huff feels 6 months is appropriate to accomplish what we need to accomplish, with the understanding that the MI case is still controlling and making sure she's doing what she needs to do, that he be afforded the discretion to request early discharge. I would also ask the court to consider waiving any discretionary fines and costs if possible for Ms. Lawfrey. Thank you.
Abby, I think you were part of the whole original discussion that resolved these cases.
I worked with Mr. Gabriel on this
Oh,
because
Mr.
they were all
Gabriel.
felony files.
All right. I guess I should remember that, but I thought Abby was plugged into it also. Anyway, Ms. Stoll, what would you like us to know?
Your Honor, I agree with the recommendation. I think it's appropriate. I haven't been at least to my knowledge, I haven't been involved in this case up until today. So I'll defer to Mr. Huff to sort of elaborate on.
All right,
what's being
thank you.
recommended.
Maybe I misremembered. Matt, this was not an easy assignment for you. What else would you like us to know?
I mean, just to highlight from the report, I think the question initially was what's going on in this case, in particular, because she has a lack of criminal history. And then we have some extremely alarming behavior. I typically suspect substance abuse in a circumstance where I'm just reading on paper. But after speaking with Mr. Lowry, I understand that I think this was a mental health crisis. This was a mental health break that occurred. She had a divorce going on. She had some issues that had kind of been building up, and she stopped taking care of her own mental health. It wasn't being addressed. There were also a couple of unique factors that I want to draw attention to, at least as reported by Ms. Lowry, in that the first incident, while it does not justify her behavior by any means, there was an off-duty officer that had arrived. She indicated that in her mental state at that point in time, she was quite convinced that she was getting kidnapped. Again, it doesn't justify the behavior by any means, but I think it speaks to where her mental status was back then, and it plays off of a verifiable fact of the case. Same thing with the second time around. In my experience, I don't see a whole lot of cases where defendants are arrested on open warrants at their residence anymore, where an officer is seeking them out. That's what happened in the second situation. Deputy Van Dyken was aware that there was a warrant out, knew where Miss Lowry was or where she resides. And in that point, I think he called it, regardless, he told her a story that was somewhat fabricated to try to lure her away from her residence so that she could be arrested. That threw her off as well, feeling that what's going on here? Why is somebody trying to coax me out of my residence? I don't understand. And so, yeah, none of that excuses her behavior. It's still very alarming behavior. However, Miss Lowry takes responsibility for that and kind of help, I think, the court understand what sort of lens she had on with her mental health issues. The last thing I'll say is, as a probation officer, I come into contact with individuals who routinely cooperate with treatment. Some of them cooperate with treatment just because they're court ordered to and they make it to the meetings. It seems as though when I talk with Miss Lowry, she's genuinely plugged into her services at Pivotal, and she's
Do we
trying
have
to
a release?
I I don't believe I have an information release signed.
I know one was executed for me by Miss Frank when she was in custody.
Ms. Frank from the jail, who was our liaison from Pivotal, helped set up the inpatient treatment.
Yes.
And now she's got a new worker who's here with her, and we'll put that information on the record. But we're gonna need a release signed to confirm what she's doing. How long was she in the inpatient?
When she was released, I believe she was there about 7 days, is what she reports to me. So after the plea was entered, she was taken from the jail around 3 o'clock, she says, to Three Rivers ER for an evaluation. And from there, they transported her to Beacon and Battle Creek, Beacon Behavioral. And she was there about a week, and then she was released.
Her bonds were amended to allow her to be released from the jail directly into the MI petition. This is certainly better than a competency evaluation, because I don't think she was incompetent. And I appreciate the intervention from Pivotal and the ongoing services. Ms. Lowry, what would you like me to know?
But I'm really trying my best at what Pivotal and the probation has outlined for me, that I am regretful for my past behavior.
Where are you still living in Flowerfield?
It's Three Rivers by Quarry Lake Orchard, sir.
Oh yeah, you told me that, and I keep it's tucked away back in there. Who are you living with?
I live by myself.
Do you have a driver's license?
I do, sir.
All right. Well, you can get back and forth to your appointments. Your worker is here with us. She's helped us with several other cases. I'll just ask you if you'd identify yourself for the record.
Anna Farley, acting supervisor. Farley.
The ACT team is a higher level of supervision from community mental health. You meet with her at least weekly?
Yes.
Do you administer the medication?
Yes.
We need more ACT team. We got more people that could benefit from that service. It's an alternative to inpatient placement. Certainly much more cost effective. The first one was a traffic stop on May 5th, May 3rd. She was driving erratically with tinted windows. Tinted windows was not why she got stopped. She slammed on her brakes and was driving fast, and then she stopped at the stop light, and then the officer made the stop, and she started to get unruly, and then Officer Hanson, who was off duty from White Pigeon, saw the circumstance. He's in plain clothes, and he stops to help, and now things just went downhill. Then she got in the car on the way to Centerville and was still very unruly, broke the frame out of the vehicle. That's the malicious destruction of property charge. Then, when they went to arrest her for failing to appear in June, Officer Van Dyken didn't want to have a confrontation in their house. As Matt indicated, there was some sort of a ruse to get her out to go check on her car. And that didn't go well. And then they had another Donnybrook. And She was not doing well at that time. The other thing that bothers me is this long pattern of harassing Miss Kerr. You made a bunch of phone calls threatening her, harassing her, which was indicative of mental health issues at that time. So one of the conditions of the probation here is you're not to have any contact with Miss Kerr, or I'm gonna find that that is a violation of your probation. All right, we have 3 actual judgments to do. I'm only gonna put you on probation on one of them. Abby, I don't believe we got any restitution request from the sheriff's department.
No, I did not see that.
I
Your
didn't
Honor.
see one. This isn't marijuana. Marijuana may be exacerbating your issues, but this isn't somebody that used too much marijuana and all of a sudden developed mental health problems. But this is, as Matt put it, a mental health crisis. The malicious destruction of property charge. I'm going to order 26 days, credit 26 days, concurrent with the other 2 files, which are 26624 FY and 261164 FY. Fine, and that is 0. What is your source of income?
I'm currently applying for different positions, but I'm having to DoorDash for my
All
primary
right, so you're still
income right
door dashing. I didn't know if you had applied for disability but you're still seeking employment.
now. I'm still working towards employment.
All right, very good. All right, on the R&O from Deputy Van Dyken on June 14th and other officers. Over 26 days, credit 26 days. Concurrent with the other 2 cases, which are 26624 FY and 26825 FY. Case you're going to be placed on probation for is the original stop by Officer Flynn and Officer Hanson. The May 3rd event that started all this. Altogether, you resisted or obstructed about 6 different officers. They stunned you, they tased you. You were really in a bad state. I'm gonna put you on 12-month probation. I'm not sure you're ready to be discharged after 6 months, but the probation department does have the discretion to discharge from probation when they feel appropriate. No contact whatsoever with Jessica Kerr. That means no contact. Facebook, Instagram, Snapchat, any source, phone. I'm going to make the fine 0. But there are things that I have to assess. There's a $75 crime victims' rights fee, a $50 state minimum fee. I will waive your attorney fee. There's $480 probation oversight fee. You were able to post some bonds, so you must have some source of income. 125 plus 480. 605. No drugs and no alcohol, including marijuana. They're contraindicated for your medications. You're comply with all court orders from the probate court. Cooperate with pivotal. Take all meds as directed. and sign a release. No assaultive or threatening behavior. We have, I think, 26 days credit. Is that what we determined? Lower than 90 days jail, credit 26. Leaving 64 days deferred. This would be very easy to order a jail sentence, but it was, as Matt said, and we all agree, a mental health crisis. But it extended over months. You were threatening that lady from October through February. I don't know what happened after that. You got arrested for this in May. There was the incident at 131, the incident on the way to the jail. And once you got to the jail, there was the other incident on June 14th. So this mental health issue was going on for months. With the help of Miss Frank and Miss Farley and Pivotal, I think we're on top of it. All right, I want to get a release so we can see how you're doing. I have no reason to doubt your indication that you're doing well. Miss Farley is here, and that's a sign that you are. And I'm not going to put anything in here regarding employment. I'll leave that up to you. Certainly, full-time employment helps everybody, or at least some employment. All right, I want you to go with Mr. Hoff. He's going to get you plugged into your probation. What I'd like to hear here is nothing in the category of no news is good news. It means you're complying with the pivotal, taking your meds, not harassing this other lady that you were mad at. That would be good. Mr. Huff does have the discretion to discharge you from probation early. I won't be here by that point, but I hope that your life gets better. All right, you go with Mr. Huff.
Thank you.
All right, it is the time for sentence in the matter of People versus William Floyd Weller III. Mr. Weller was charged with aggravated stalking in this file, which is 26872FY. It's a felony. The matter was reduced to misdemeanor stalking charge. The defendant entered a plea to that charge, and I scheduled the matter for sentencing this morning. I wanted to get a bigger picture of things. I wanted to have an opportunity for input from Kristen Sullivan, the complaining witness who is here this morning. So I've reviewed the information in the affidavit and the report. I've reviewed the victim impact statement. And it is here with his lawyer, Rhonda Ives, and Abby Stoll is here from the prosecutor's office. Ms. Ives, what would you like me to know?
Well, Your Honor, my client believes that that he and Miss Sullivan are very toxic together. He also agrees that he needs to get some treatment for his own behaviors. But I was reading the victim impact statement, and there's a lot of pieces in here that my client just finds very troubling. I mean, he had pictures of her on his fridge, and he still cares for her and he still loves her. I mean, the things that she complains about are not, he's not trying to be creepy towards her.
Well, the pictures weren't so weird, but the underwear was weird.
Well, I don't know if he totally admits that's the way that conversation, went. But I think it's more for an adoration of her, but he also realizes they're very toxic. And since I've been in this case, I've made it clear to my client that he cannot have any contact with Miss Sullivan, but yet she continues to just contact him over and over again. And July 29th, 11:35 a.m., July 29th, 11:46 a.m. And just numerous, I don't know, some of these don't have the dates on it, but almost all of these have been this summer. I know you're sending my messages to Rhonda. I don't care about that. I do hope that we can work on things after court because I do love you more than anything. And I want you to know that I am at a very emotional state because I want this so badly to work with us. And please also know that even though this is hell for me, it came from a good place. I want us to get better together. I'm doing this for you so we can finally have a future we wanted together. I understand that Rhonda is going to see these. Everyone knows how I feel, probably even the judge. Even though you're not going to respond, I want you to know I'm here and I'm fighting for us to grow together. How I feel has not been a secret to anyone. I just have to let my feelings out to let you know where I stand, and we can work through everything else together. Rather anyone understand or not, it's how I cope with the situation. Even though it's bad, I did this because I love you and I believe in you and us. I have to talk about it to get through this.
So
And
you
then-
could, hold it, you contend that's a text that she sent to your client on July 29th?
Yeah, you know, I don't have the exact date, but it's since, I've got other text messages from July 29th. I don't know the exact date of that one because the date is not on this. I mean, I'm happy to show them to the prosecutor. I mean, there's literally numerous text messages from her number to him. I mean, one here on August 9th, this no contact shit has hurt me emotionally more than anything that we have been through, and I can't stand this. This isn't fair. We should be together right now. I would take what happened between all the fights and arguments and the crazy over this separation any day. It hurt me more than words can express. If I had the chance to do this all over, I wouldn't have done it. I miss you and you mean the world to me. I've been thinking about things and reflecting on stuff since this happened. I want to fix this damage it caused for our relationship more than anything. I mean, they're just oodles of them. My client has wanted to respond. I've told him absolutely not unless you want to end up back in jail. You will end up back in jail if you just even say hi or thanks or I can't talk to you now. And this is just kind of a sampling of some of the messages that I would like to provide to the court, just so you can see what my client, you know, from his end, because he does still love her and he hasn't been able to talk to her. He knows they're volatile. He knows that they can't have a relationship in the state that it was in, but you know, he would indicate that she has a lot of mental health issues as well. You know, she's at one point she was talking about being pregnant and she's talking about having a sexual transmitted disease, and I don't even know, but I don't want to go into that on the record. But it's just really, it's a lot. And I know she's here today, and I did call her today, and I asked her that I think she should be here because I think she needs to share with the court her honest opinion. But I also know from my client's standpoint, you know, some of the contact that he has had with her, you know, in this matter has been her just continually bombarding her with messages. And this isn't just since I've been involved in the case. This has been ongoing for months. And he responds. And of course, here we are with the stalking charge.
Miss Sullivan, would you come up and have a seat with the prosecutor? Good morning. These are all new revelations to me. In preparing for this case last week, I looked at your victim impact statement, looked at the affidavit, reviewed the original PPO petition. And now I find the allegations that you've been contacting him repeatedly after the plea. Now, his lawyer gave him the correct advice, don't respond. Are these texts that you sent him?
Yes, sir.
All right, well, what do you want me to do? You can't have it both ways. You can't have a PPO and complain about all the things that you allege that he did, and then text him and tell him how much you love him and you regret the whole thing. He's in a tough spot. Well, let me repeat this. The PPO is in effect, says you're not supposed to have any contact with him. Your lawyer with her gave you the exact advice. Don't answer. But some of the stuff in the PPO and in your victim stuff, he doesn't like the fact that you have a mixed race child. And he throws that up, and there's weird racist undertones to this, threats of if they're accurate, terrible things to you and your cats and your kids, and cutting your head off. And so despite all that, you've been contacting him right up until last week. I am glad you're here today. What do you want me to know?
Well, I came out here with the intention to know what I was going to say today.
I'm going to ask you if you would speak up.
No.
The mic's right there in front of you.
Can you hear me now?
Go ahead.
Okay. I know he's got a lot of problems, and even though he has a lot of problems, I've begged him for many years to get counseling, and he wouldn't do that. And I've tried to stand there and say, Willie, you have to get help, and he wouldn't listen to anyone. He wouldn't listen to me. He wouldn't listen to his family. He wouldn't listen to anyone. So I felt at the time that it was unsafe. But through all of this, I've come to the realization that no matter which way it goes today, it's gonna hurt. So, I have documentation of everything that Rhonda has said, questioning my, medical, history, and I have proof of everything. I brought it with me. And I guess what I'm asking you is, I don't want to see him go to jail. I just want him to get the proper treatment, because I feel like he has some mental illness.
Well, I think he even accepts some of that, but you got this personal protection order. That's yours. You petitioned the court for an order for no contact. You can lift it. You can ask the court to drop it. But it's still in effect.
Your Honor, I want to correct you. Excuse me for interrupting, but I thought the PPO order, I thought it expired on July 10th of 2026.
Okay, did it? All right. So
I believe the PPO, unless the court.
I have the petition. I don't have the actual order.
Unless she renewed it, I'm
so
looking.
The PPO expired on July 10th?
Yes, sir.
All right. So there was not a PPO in effect after that. There was a court order that he not have contact as part of this case, but the PPO expired. All right. Thank you, Ms. Ives.
You're welcome.
All right. So you don't want me to put him in jail. The PPO has expired. Do you wish to be able to have contact with him?
I feel at this point we really need to, due to everything that's gone on with my medical, and it's just a lot easier because I feel like I'm dealing with a lot on my own. And there was a point in time where he was always around. He was always a support system. But as I said, as time went on, it just got worse to the point where I feel like he has mental illness. And I fight for people with mental illness no matter what. And I've known him many years, and I do have love for him. So my whole situation is I just want the best for him. I never really even wanted him to go to jail when he did. But he kept fighting me on it. I told him, you need to go and talk to the judge and try to get some help. And he just refused to come in and do things. So when it hit, I think it hurt both of us, but I tried to get him to do the right thing. I'm a very caring person.
Well, he said many very, very cruel things to you. over an extended period of time, keep humiliating, degrading, talking, degrading about you, your kids. And that wears on a person. Someone telling you that you're worthless and, but this took me by surprise. Probably you as well, Miss Stoll. Were you aware of any of this?
I wasn't, Your Honor.
So with that in mind, she acknowledges all these. I'll accept these into the record. What do you want? What's your thought at this point? I came in here fully prepared to just give him a jail sentence. The PPO is expired. She doesn't want a jail sentence. I do think he could benefit from a probation and some counseling. Maybe we could accomplish a little something. And I'm going to lift the no contact. When I looked at this Friday and again this morning, I thought, well, this is just jail. All right, Mr. Weller, what do you want to tell me?
Well, throughout this whole thing, it's just been an emotional wreck for me. The emotional roller coaster a lot. There is a lot of stuff that I did say to her that I probably shouldn't have, and most of it was out of anger. And I know she knows me. I did check into counseling on my own. I haven't met with her face to face yet, but I also have to pay for it out of my own pocket. I was trying to do something like that on my own rather than it be court ordered. Her name is Sarah Flowers. She just opened up another shop in Sturgis. She's actually like 5 minutes from my house.
Have you reached out to Pivotal or you're just prepared to do it?
I did reach out to Pivotal, but every time that I called them, they just either put me on hold or ended up hanging it up.
Where are you working right now?
How Restaurant and How.
Still
I've
there.
been there for like 22 years.
And Your Honor, just if I may add, I'm not sure if these parties really should be having direct physical contact. I mean, I don't know what my client feels about having, communications via text message or communications through verbal communication, but I think both of these parties need some counseling. I think Ms. Sullivan has some own mental health issues, just given the conversations I've had with her and the fact that, she has a codependence issue as well, which I think is clear. And I think I just think they both need to have their own counseling. And I just want to protect my client. And I think physical contact could be, I just don't know. If that's a good thing right now.
Well, at least they can talk to each other. It took a while. This warrant was issued in March, didn't get served until June. He got arrested on June 24th, posted bond on June 25th. I have a $300 bond. We'll do a 12-month probation. I'm going to order 11 days jail credit 1, leaving 10 days to serve. Of the 11 days, 10 are deferred. I came in here thinking I was going to do about 30 days of jail. But there's more to the story than I was aware. I think the things that were alleged in the PPO and in the victim impact statement are true. But then the other side of the coin is the things that you're sending to him are true. The PPO has expired. So that's not an issue. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $480 probation oversight fee, and a $55 fine. $350 minus $270. The court keeps 10% of a 10% bond. $580. Due in 12 months. Could be discharged potentially early. Counseling. Sign release. If nothing else, we can put you in a domestic violence course or at least anger management. No drugs and no alcohol. I don't think drugs or alcohol are a factor here. I think anger and racist thinking and demeaning thinking may have phone or text contact or email till further order of the court. We can allow in-person contact after we get plugged into some counseling and see how you're doing. At this point, you may contact each other by text, email, and even talk on the phone. But you can't have physical contact until I get more assurance that everybody's safe. Mr. Weller, I was concerned about what a straight jail sentence was going to do to your job. Probably would have lost it. So now you're not going to jail. I got jail hanging over your head. All right, Mr. Weller, you take this form off to the counter. Ms. Ackman, would you escort the complainant out? They can talk on the phone, but I don't want to have them. I think you're at the court building.
So they need a report to probation today?
Yes, he's gonna start over there and they'll get him plugged in at least to set it up. I want to know more about your counseling. I want to get a release. If we can't find counseling, I could put you in the anger management program. Might be better than nothing. But this is more than just anger management. There's other issues here you're gonna need to address. All right, we'll be in recess. Thank you.
Thank you, Your Honor.
All right, people against. Scott Michael Bearden, 260-710-492.
Good morning, Judge and staff, and welcome back, Judge.
Thank you. Your appearance?
I'm not saying anything on behalf of Scott Bearden, moving my left. Please identify yourself, sir. Scott Bearden.
All right, so we have a charge here of failure to refrain from consuming alcohol, testing positive on a chemical test on July 14, 26. Just for the record, this was adjourned because the defendant had an issue that prohibited him from coming last time. So how was he going to proceed on this?
Judge, he wishes to plead not guilty at this time. I asked him many times, as was told, that you got a little bit of a relapse. He strongly denied it. It appears he spent roughly about two weeks in the hospital since that period of time. We have evidence of that, Judge, and he's frankly in really bad shape, and it appears that in addition to the spinal capsule, he had a hip surgery in the future.
All right, so for purposes of arraignment, I'm going to enter a not guilty plea form. Are you ready to proceed? Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got. Okay, go ahead.
Yes, Your Honor. On July 14, 2026, I received notice from DNA that Mr. Bearden was positive on ETG, that while he was there, he had refused to sign the admit form or send it to the lab. In my communication with Mr. Bearden, following, he did email me and indicate that he was positive, that he did not have the $25 to send the sample to the lab. I did inform him that he would have to return, that if he was refusing, he'd have to return between 5 p.m. and 7 p.m. that day. This would actually be on the 15th, Your Honor. And that if he's indicating, hey, I didn't drink, he would actually receive his $25 back. If the confirmations are returned negative, defendants do receive the money back, Your Honor. He responded that he didn't have the money, and that he wanted to speak with the judge about it. Emailed me again, indicating that he claimed it was NyQuil.
Oh boy.
Went on from there kind of a little bit. Then when I met with him for his probation visit, I tried to speak with him about it. And what he indicated to me at that time was that he just wants to go to jail. It would be easier, and that he would let you know that when you had his court date. So that's kind of where we left it, our conversation in regards to that test at this point, because the test was July 14th. That urine sample would be disposed of, Your Honor. It is only good for 30 days.
Right. You have a screening report with him?
I do.
What does it indicate? Does it indicate where he was working?
I believe he's on disability. I'm going to double check the screening, but I believe even at the time of the screening, reports being on disability for the last 4 years, he received $741 in SSI and $321 a month on Rich Start benefits, Your Honor. That's what's in the screening.
Okay. Do you have any questions of her?
Judge, all I'm going to indicate, and Mr. Bearden will confirm with me, is the fact that thinking clearly prior to that incident, one, he needed a spinal tap. He was, again, thinking clearly. Number two, he didn't even have the $25 to pay for this. He's a part of the other half that's lucky to have anything at all, Judge. Like I said, he probably doesn't even have $20 in his pocket right now.
I also want to say it's for the next screening, which has not been one since I've been out.
Also, he indicated to me that he was not thinking clearly at that time. There's evidence that he did have a spinal tap. He's going to be in a position where he has to have hip replacement surgery. In addition to that, then they have to do something to your spine. Tell me what happened.
I had a blood.
Let's just talk about that. Let's just talk. First of all,
this does relate to that incident.
I know, but is he going to testify or is he going to remain silent?
He's testifying his law. We've got nothing.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes.
All right, go ahead.
Explaining.
Yeah, I've been in the hospital a lot lately.
How much time?
At least.
Okay, when?
First, this is the second time where I had a blood patch, which is I would have no problem. Next minute here, I would have no problem giving the court of my chart. Which
hang on a second. I just want to know when you were in the hospital. What day? You weren't in there on July 14th, right?
I have no idea.
You didn't go in there before July 14th, right?
I was in there before July 14th.
For what days?
Let's see. I would have to look at my chart.
Did you drink alcohol?
Absolutely not. I was in the hospital in Monroe County. I had been out for 1 day and I was on bed rest. And my wife is not going to go and get it because I'm not allowed to drive unless it's absolutely necessary. And there's no alcohol in the house. They did not find narcos in the system, which is prescribed me, and I told them that. They asked me when I went in there, do you have any narcotics in your system? I said, yes. I have a narcotic in my system, which is normal. 10-3-25. They do not find the normal, but they're going to find alcohol. And I said, that's possible. And they said, well, if you give the $25, I was like, I don't have $25. Like in my pocket right now, exactly $26 waiting on the orange test. So, Your Honor, I don't know how they found alcohol, but not my normal.
That's his color, Your Honor.
What's that?
He's referring to the date that he has to.
Orange is, I call in every day. And whenever it's orange, I only you gave me once a month to go. So since I've been in the hospital, I've been calling. I only have 26. That time they told me to give them $25. I don't have it. Had it went in.
Does your wife work?
No.
She's on disability.
She's on disability. She's worse than me.
They're living on the edge, Judge, and they're lucky to even get this apartment.
Tell me,
I don't know what else I can say further. Again, Your Honor, when he emailed, as far as the Norcos are concerned, it's undercut. That's why. These are things Mr. Bearden's not aware of. Again, try to have a conversation with him. I ended it after kind of the bad attitude and the bad comment in regards to he'll just go to jail. I ended our conversation. And again, you know, what he's claiming it was NyQuil. And
Did you tell her you took NyQuil?
That could be the only thing I'm thinking of.
Did you take NyQuil?
I take it once or twice, but once I got found guilty, or not found guilty, but wasn't came back positive, I threw that bottle away. I'm like, because I want no.
NyQuil's not going to cause you to test positive.
There we go.
I know that's a nice thing that people want to throw around, and unless they get 7 bottles of it.
Judge, I just want to indicate that Mr. Bearden wasn't rational. He was having these severe headaches. It's necessary. His wife was in the courtroom can indicate that fact, and as a result of it, he wasn't acting properly.
I'd like to apologize. I was acting like a jerk on that. That's
Well, why?
the headache that I had, and I was
Headache?
just frustrated.
Okay, we all get frustrated. I get frustrated because I get people lying in me all the time. Anything else?
I don't have anything further, Your Honor. You know, if it was NyQuil, if it was anything other, it needed to go to the lab. And I'm at a loss again after 30 days. It isn't anything where even Mr. Bearden had the $25 to send it now. It's not. It's an impossible.
No, I know.
Yeah.
Any argument?
Judge, I'm just going to indicate I'm asking for continuation of probation, no jail time. This, I asked Mr. Bearden numerous times because I know you're aware of all these BS movements, so to speak. But again, he was adamant. He was quite adamant that he must spend a deal of time in the hospital. And in fact, he has an appointment today at 1 o'clock to determine when he'll get scheduled for this hip replacement surgery. Like I said, significant spinal taps. If it's necessary.
I'm not sure I can justify his conduct based on any of that, though. I'm going to find him guilty as charged of consuming alcohol.
Judge,
I think he's just making this worse, trying to tell us it's NyQuil, saying he wants to go to jail, telling us the headache caused him to
Judge, headaches.
Act differently. I mean, everybody has headaches.
Judge,
I mean,
these are more than severe migraines. This is a headache for a person will pass out. And it causes human beings to act irrationally. In fact, Mr. Bearden has indicated that he didn't pass out.
you don't really want to go to jail, do you?
No,
Well, why don't you tell her that?
because I was a jerk. And I'm sorry. I know the headache is not an excuse. It's frustrating when I seen the time frame that I had to have community service done, which I knew was impossible.
Judge, for the record, that will also be another issue.
Well, he doesn't have his community service done?
No,
He's also not involved in substance abuse treatment and lacks attendance to his 12-step meetings.
Why?
I haven't been in and out of the hospital.
Listen,
I
how many days? Let me ask you a question. This is August the 17th. I sentenced you June the 2nd. That is 28, 59, 69, 76 days ago. Okay? How many of those days have you been in the hospital?
not that many.
How many?
I've been in a hospital, but it's 1 out of that is.
Why didn't you go? Why didn't you go to AA during that time? Why didn't you get into treatment at that time? Why didn't you do some community service at that time? You're pushing me, and it's not going to end well for you.
I will complete it.
Well, I mean, you want to be belligerent toward the system. That's okay. I see that happen. Some people hate the government, hate this, whatever. I get it.
I don't feel he's being belligerent.
Well, I mean, I'm going to state that again. I think he's just adamant that nobody's going to tell him what to do. That's what I think. He can take it however he wants. He's getting smart with the probation officer. He's telling us he was on NyQuil. He's saying he can't do this. Wants to go to jail. Have you seen proof of any of this medical?
I have not, Your Honor.
Well, we'll want to see that.
Can I present it to Ms. Watts first?
Sure.
That's next.
So you can make this as easy on yourself or as hard on yourself as you want, Mr. Bearden.
Really easy.
Well, so far it hasn't sounded like that to me. Give you 8 hours of community service. Sounds like you're having financial problems. I won't assess costs.
Thank you,
You're gonna do all 8 hours of community service and the other 32 no later than September the 14th.
Your Honor, I have to have it. I go today to work it out.
You come talk to me. I don't want to speculate. I'm not going to engage in hypotheticals. You looked like you walked up here fine to me. I'm not. Well, maybe you're going to have surgery. I get it, but let's not talk about hypotheticals here. You have not been doing what you're supposed to do, and I would make sure I started doing it today. You understand what I'm telling you? Otherwise, we're going to have a big problem, you and me. Okay?
I have 40 hours down by September 14th.
That's what I just said. I meant it. I said it, and I'll say it again. 40 hours by September the 14th. And you better start going to AA, as I told you, and you better get into substance abuse treatment, like I told you. I'm not impressed with how little you've done so far. You got it?
Sorry.
Okay, good. Thank you.
Thank you, Your Honor.
Francisco Elijah's Cantu, 25F244-762A.
Judge, good morning.
Good morning.
P-Tech Williams, and we have Francisco Exes.
Good morning, counsel. You got your work cut out for you in this one. Your name?
Francisco Gentu.
All right, so what happened is you guys were in here. There was a plea of guilt on July the 20th. And the other charge was that you stipulated we treat OWI conviction as to count 2 and a non-technical and R&O as to count 3. And we treated count 1 as a technical violation, which was consuming alcohol. I ordered him on a sober link at that time. And then and your name is O'Donnell?
Yes.
It says on August, so she said, see attached screening and police report regarding the new charge. You ordered for him to obtain did you get a chance to see this? This report that she did, prepared in the file?
No, Judge, I didn't. If it's just
Here, I'll just read it to you. It says you ordered for Mr. Cantu to obtain a SoberLink device on July 20 when you last saw him in court. He did obtain the device on August 9. There was a positive blow on the SoberLink device at 6 p.m. with a result of 0.046, and then he failed to comply with the retest blows as follows on August 9th at 6:15, 6:45, 7:15, 7:45, 8:15, 8:45. And then she added on August, today it looks like, right? August 17th, over the weekend, the defendant tested positive on a SoberLink device and failed to comply with the retest blows. On August 15th, positive blow on SoberLink device at 6:25, and then failed to comply with the retest blows. So we've got 3 instances, correct me if I'm wrong, 3 instances where he tested positive and then didn't follow up with the retest.
So it's August 9th there was an incident, and then August 17th was the incident.
I see. My apology. I thought you were adding that on the 17th. So we've got 2 of those. So we're here for sentencing. I'll listen to anything that you have to say and we'll go from there.
Judge, if you recall, you also ordered my client to get into an IOP, and you ordered my client to finish community service. He finished his community service, and for both the case up north in Standish as well as this one, he was not able to get into IOP because he doesn't have any insurance. To his credit, I gave him a lot of places, and I believe that he called them trying to get those done. Judge, he's paid in full, and the SoberLink it's unfortunate, and it tells me he didn't drink. Obviously, we all like to believe that. Would have been real simple.
Well, I'll give him a hearing on that if you want.
No, Judge, just what I'm saying is.
No, wait. Let's slow down.
Yeah.
If he says he didn't drink, I'll be happy to give him a hearing with respect to the SoberLink blows on August the 9th and August the 15th. I'll be happy to do that. That's not fair for me not to give him a hearing. If he's going to deny that he drank, let's have a hearing. If he isn't going to deny that he drank, then he can plead guilty to it. But I'm not going to proceed on the basis that he drank or didn't drink if he's denying that he drank. Right?
Understood.
So what does he want to do? If you need time to confer with him, I'll be happy to listen.
I don't need time to confirm. Can I approach with Mr. Donald briefly?
So is he going to acknowledge that he consumed alcohol on August the 9th and 15th, or what's he going to do?
This is what we're going to do, Judge. My client conferred with his schedule and his phone and even texted his girlfriend. He's adamant that he did not drink the 9th or the 16th. However, Judge, on August 1st, when we were in the hallway discussing those, Todd, honestly, I didn't drink last week, but I drank August 1st, texted with his girlfriend, confirmed it. He took his last sober link at 10 p.m. on August 1st. He and his girlfriend consumed alcohol on August 1st. He did not test positive in the morning on August 2nd.
August
1st. My client.
Yeah, I know, but August 9th and 15th, you say you got a positive blow, right?
Correct.
So we're going to at least have a hearing on this, okay? So he can admit he consumed alcohol. He can deny it. It's fine that he's denying it. We're going to have a hearing on those two, and I'm going to make a determination as to whether or not he consumed alcohol on August the 9th and August the 15th. All right? That's what we're going to do. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you got.
Thank you.
Go ahead.
Two counts. My first count is on August 9th. There was a positive blow on the Soberlin device at 6 p.m. with the result of 0.046. The defendant then failed to comply with the retest blows as follows. These are all dated August 9th of 2026. He failed to retest at 6:15 p.m., 6:45 p.m., 7:15 p.m., 7:45 p.m., 8:15 p.m., and 8:45 p.m. My second count is on August 15th of 2026. The defendant submitted to a Soberlin blow positive at 6:25 p.m. with the result of 0.076. The defendant then failed to comply with the retest blows as followed. These again are all dated August 15th of 2026 at 6:40 p.m., 7:10 p.m., 7:40 p.m., 8:10 p.m., and 8:40 p.m., and lastly 9:10 p.m.
All right. Do you have any questions, Hal?
I do. Also, Donald, it's possible in your experience, an individual test and think they passed the test and walk away from the machine instead of going back and reloading, whether it
could be possible. Every time they're instructed on the device, though, they are told to make sure the device is submitted. A lot of times when the device is positive, it'll show that it says retest in 30 minutes. So they'll always, respond to make sure they take a look at the test to make sure it's submitted and that it's
So in other words, if an individual like Mr. Cantu gets comfortable, so to speak, with passing tests, goes in, blows, folds it up, closes it, and doesn't follow it, then it will go through the protocol showing that he failed to retest. So it is possible in certain circumstances that there could be an initial positive, waiting for the reaffirmation. But if the client doesn't follow the instructions, doesn't read the instructions, doesn't listen to the demonstration and picks it up, then they could, in other words, they lost the opportunity to prove that they hadn't drank alcohol.
It's definitely possible for them to do this.
So we don't have 100% confirmation that he drank alcohol. Those minutes, however, there was the VAC accepted by the machine, but because he didn't reaffirm that he retested, low number.
Correct. Those retests would have been able to confirm if it was an actual positive or if it was from an environmental factor, because those retests would have worked there.
But we are confident that he had those instructions, obviously, because there were several other tests where he did it right. I have one question as you look back in your notes. Did he ever have another instance where he did have a positive reading and then he did follow up with the reaffirmation, the retest?
No, he did not.
Thank you. I have nothing else, Judge.
Does he wish to testify?
No, Your Honor, my client can be set.
Any argument? Either one of you.
Judge, other than obviously we had a positive test, it's unfortunate that he didn't get back on retest. Other than that, I hope you take into account that my client did admit to consuming alcohol against your orders on August 1st.
All right, the court finds the defendant did in fact consume alcohol on August the 9th, that he tested at 0.046 and then failed to submit to the retest, and furthermore, that he tested positive on August 15th for alcohol and then did in fact consume alcohol, and he had a 0.076 reading and then failed to submit to retest. So this is where we are. I want you to remind me, on the drunk driving that was adjudicated, that was in Standish, correct?
Correct, Judge.
How many days did the judge give him there?
The judge was 24 days he gave him, and I believe he did 19 days.
Anything you'd like to say before I sentence him on this?
Process closure, if you want to tell the judge.
Definitely, not proud of my decisions so far, but I definitely feel after everything's said and done that I will learn my lesson. And yeah, yes.
Did you ever talk to your probation officer about the fact that you didn't have insurance to get an IOP?
I did mention it one time.
We did. We talked about the 1-800 number. He was going through, I believe it was Sacred Heart, and Sacred Heart will take you if you don't have insurance.
Right.
You can go through, the questions and everything like that. I'm not sure if he went through all of that with them, but I know he was in contact with Sacred Heart last time I know.
Did you? I contacted them and they said that they didn't have a ILP in their area. So they they gave me a recommendation number, and that person ended up giving me multiple different numbers that I called, and some of them were a bit expensive, like $200, $300 a day, 3 times a week, and I can't afford that out of pocket.
Anything else, Mr. Williams?
So other than he completed not only his community service for here in Standish, and that was the last hurdle that he had for Standish. Paid his money in full, and
He's paid all ours.
right. He has, as well as other one.
Judge, I would like to add this for us. He has 4 days credit jail. For 1 day that he served while he was in custody when he was arrested, he did 2 days on the court work program, and then he completed 1 day of community service for us.
You know, your lawyer gave a very spirited argument when he was here before. And he did a really good job for you, but he can't save you from you. There's no doubt in my mind you were drinking after we had that hearing, whether it was on August 1 and certainly, I believe, and found on August the 9th and 15th. And after you went through 2 drunk drivings, I would have thought you'd stop that. I get the fact you had an addiction problem, but you made up your mind for whatever reason you couldn't go to IOP, and then you still kept drinking. And the reason I wanted you in IOP is I wanted to help you. And frankly, I'm not sure I would have done what I'm doing today had you followed the rules and been abstinent from alcohol and drugs. I'm sorry, probation's revoked. You're to serve 45 days credit for 41. I won't assess any costs. You've already paid that. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Thank you, Mr. Williams. Have a good day.
Judge. Thanks for letting me decide to consider it.
Have a good day.
Zachary Grover, Craig Matson.
Hello, Your Honor.
Good morning still to both of you. Raise your right hands, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
All right. Mr. Grover, you still living in that car?
I don't live in the car. I stay out in it to watch the neighborhood because we have a bunch of homeless people that come by day and night. We've had our car broken into twice, and stuff gets stolen from people's property all the time. And not only that, I have a back problem from when I was in an accident. So me sleeping inside where I used to sleep causes issues, unlike me sleeping in my car. So I sleep in my car. But other than that, yeah.
Okay, so best I could tell is that your concern is that Mr. Mattson walks by out on the road and has a boombox with him and plays music, and
No,
you think
that's
that's intended to annoy you?
no, that's not even close to what's been going on. When I first found out about Craig Mattson, it was about 3 years ago. I had no clue who the dude was, and the only reason I found out about him is because there's these two ladies that feed the stray bowling alley cats that have been there for 10 plus years. Animal services have been out. They they're the ones who leave them there. They'll get them fixed and spayed, and then they'll drop them off. But I met the nice two ladies who feed them, and one of them's probably about 80 years old. She walks with a walker, and she was the first one to tell me about this crazy guy who would literally stalk her every time he sees her out.
Okay, so Mr. Grover, I'm going to stop you. Just tell me about your contact with Mr. Mattson. Let's just focus on that.
I was only saying that because it's pretty much what he was doing to them, he's doing to me.
So explain that. What do you?
He'll come home, come over to my house and start harassing me whenever he sees me out. He's threatened to beat my ass multiple times. I actually even have a neighbor that's out right now that could tell you exactly what I'm saying. It became a daily thing where he's came out and harassed me and just wouldn't stop. And then, like I said, the boombox was one part because he deliberately came and sat at the very last inch of my driveway at 8 a.m. with his boombox on full blast, where it woke up the whole entire neighborhood. Stood there for about 2 minutes blasting the music, and then after that, he'd make sure to when he got off work, he would come past my house, go about a mile an hour, play certain songs that are talking about gun violence and how I'll shoot you, those kind of songs. And it's literally been nonstop harassment for 3 months until he got served. He knew he was I was trying to serve him, and he was dodging the service for most of the time, and so I was gonna have him served at work, and I didn't know where he worked. So I mean, I found out one day, and when I found out, because I followed him to work. If I have to have him served, I have to have him served. Before he got to the work, he pulled into a gas station. I pulled over too, and he made this big scene and tried to have the people at the gas station call the cops and make this scene like, this guy has so many drugs in his car, blah blah blah. And I even have a video of me telling him, like, well, call the cops. If you think I'm harassing you or this is illegal, call the cops. And he went to leave. He went to his work, and as we were leaving from the gas station, there was a cop right there. I even honked my horn a couple times to try to get his attention. The cop rolled down his window, and I said, hey, this guy, I need to have him served. And the judge said I could have police do it. And it was Thurston County or Lacey PD, and they're like, well, you need a call beforehand. So I'm like, whatever. But I've never once went out of my way to say or do anything to him. Make first not confrontation, but interaction. And yet he, for pretty much 2.5 months straight, would come over here, see what I'm doing, harassing me. He even had his one security camera in front of his house pointed directly at my house just to surveil me and see what I'm doing at all times. And
what's the distance between your two houses?
It's about 200 feet, maybe, if that. I also uploaded a couple police reports where he has assaulted a 12-year-old at the park for cussing at him, and he has also assaulted one of the ladies that I had talked about that feeds the cats. He has this really like angst hate for cats for some reason, and he like literally, like, anyone that feeds the cats or likes cats or whatever, he'll literally go out of his way just to, harass and literally stalk them. He is trespassed from the apartment from me next to me because he has messed with and harassed so many people that the apartment manager said that he is not allowed to come over there anymore. I literally have like 20, 30 more videos I could have sent in, but when I called the court clerk last time,
I watched a lot of videos, Mr. Grover. I don't need any more.
I know, that's what I'm saying. I didn't want to overwhelm you with
Okay.
I didn't
Has
even
he
really
said something?
look at what they had.
Has he said something that threatens you?
Yes, he said he's going to kick my ass multiple times, and I have witnesses to prove it.
Okay. All right. And has he made any
I can literally go up to my neighbor.
indication?
He's right here.
Has he approached you? Has he threatened, by moving towards
Me
you?
on the property many times. Yes, he has come up to me on my property. He hasn't came on my property, but he has approached me probably 10 times at least.
Okay. All right. Mr. Mattson?
Yes, Your Honor.
Go ahead.
I hope you've read my personal, all my statements that I've submitted, and I'm going to save repeating all that information. For the most part, I want to say that I have never threatened Mr. Grover. Mr. Grover, the majority of the time, he will initiate contact with me, even by his own submitted evidence. He's sitting in his car yelling at me in my driveway and at my mailbox. And one of the most outrageous things he's done is he's accusing me of following false police reports. He doesn't want to talk about it anymore because he's now found out that's not true. But this is why he's coming after me. Your Honor, can I speak? So I have proven by getting a police report sent to a public records request done on my property that says we have not filed any police reports at all in the past 6 months on Mr. Grover. He's also submitted a piece of evidence that shows the next door neighbor made noise complaints. It wasn't me. So this is all retaliation. I asked him once as he was walking or driving down the road to not rev his engine so loud. Then he's been getting noise complaints about it. He made the assumption it was me, and he's been retaliating about it ever since. He's been yelling to me about false police reports, and then recently it's been about court. So I didn't really even understand the context because I was never served papers for court, and I never filed any police reports. So I really feel like he's been harassing me.
Can I say something?
Yeah, Mr. Grover, hold on. You'll get the last word. Don't worry.
Great.
All right. So on at least one of the videos I saw, Mr. Mattson, you're walking by with the boombox. Mr. Grover tells me it's early in the morning, and you're sort of standing outside of his driveway. he does initiate he starts yelling at you, but you have your boombox. So what's with the carrying the boombox? It seems intentional.
I was on my way to the park with my dog at 8:30 in the morning on a Saturday.
He didn't go
Okay,
across the
Mr.
street.
Grover.
He yelled at me,
Mr. Grover, I'm
and I
not going
came.
to listen to you interrupt
My
me.
bad. My bad.
Go ahead, Mr. Matson.
He yelled at me, and I came over there, and then I continued to the park after that. The video was only a minute and a half. It wasn't very long, and I was just going to the park with music and my dog. The entrance to the park is directly across from his house, and it's right next to my house as well. I live about 300 feet away.
Yeah, and he needed to come across the street to me.
Okay,
Apparently.
Mr. Grover.
I know. I thought he was done talking. That's the only reason why I said something.
No, he's not done. I'll let you know when it's your turn. Okay. Do you ever think of getting some earbuds and play your music on your phone?
Yes, Your Honor. That I have. He after he made a scene about that, I have never done it again. Of course. I don't know. He's talking about driving by. I mean, like I play music in my car at a regular volume, and it's a low. It's like a 15-mile-an-hour zone, and I'm pulling into my driveway. So his other video is just me going home from work. You know, there is the long-running history of him being extremely loud with his car. I'm sure you saw some of those videos of him revving his engine and even backfiring. It's very disturbing to the neighborhood. So I find it really odd that he's making a claim that I played music once at 8:30 when he disrupts the neighborhood almost every night with his loud revving of his engine.
All right. Well, as you probably saw in reviewing the videos, he's talking to his friend and says, well, that's what, that's how you get going. You push the accelerator on a car and it might be loud, but it seems to you more than that.
Well, he has removed his catalytic converter and his muffler system, so he has no exhaust system on his car anymore. It's a Pontiac Grand Prix GT, so it is kind of a sports car, and he's taken all the exhaust system off of it, which makes it extremely loud.
Have you told law enforcement that? Because you're not allowed to do that.
There's reports in law enforcement reports about his noise complaint about that. He needs to put a muffler back on his car.
All right.
Those complaints were not made to us, though. We never filed a police report against him. Like his accusations say, that is unfounded.
All right. Thank you. Mr. Grover, you get the last word. Go ahead. You're muted right now.
Not me. Oh, there we go. There we go. Yeah. So I'm just gonna say, if he was going to the park with his dog, the park's on his side of the street, and he would have no reason to be on my side whatsoever if that's what he wants to say his reason was for playing the music. And two, the police report that was reported on me, it says the house that has the car that's revving is directly west from the property. Even though it doesn't have his name on it, my house is directly west from his property. Literally, directly. So, I mean, he wants to sugarcoat it and try and come up with whatever reason. I don't rev my engine. I'm pretty sure I even submitted the video where I've talked to my neighbors where they can literally verify. I can literally go to any house on the street right now and verify that I don't rev my engine. I go to and from places. I actually had to call the cops on him a week ago because ever since he got served the court papers, he's been trying to figure out a way to get me to confront him so he can get a "oh gotcha" moment on video. The first thing he did is he had his wife's son go across the street from me at about 11 o'clock at night and knock my neighbor's trash can over while Mr. Matson held the door open for the kid to run inside and so he could hopefully record me confronting him. I even recorded me going picking up the garbage can because none of my neighbors deserve to have their property damaged or messed with, just so someone can probably catch me on video like a paparazzi. And then the second time, like I said, when I called the cops on him recently, he had a flashlight directed straight at my property, pointing from the ground. And he was trying to get me to, confront him again so he can get some kind of video on me. And I said, you know what? I'm not gonna do that. I'm just gonna call the cops because that's what I was told to do. I called the cops, and then his excuse to the cops is, well, he harasses me by driving his car all the time, and it's very loud. And the cops even told him, well, you can't say he's harassing you by driving his car because he has to drive his car. He's like, you can't say that. He told the cops that. And then the last time he tried to get a gotcha moment was a few days ago. The stray cats that I told you about, there's some that live in the bushes by the park, and they're literally like blackberry and thorn bushes. He will intentionally take his dog to go in those bushes where they are fed so that the dog will piss or shit on the food. He's also kicked the food and used a leaf blower to blow the food in the bushes. So last time I seen him take his dog over there, I made sure to record it from my property all the way to the spot to show what that spot looks like, which it is all thorn. And as soon as I got like within 5 feet of the spot, he watched me walk up the whole entire time, and he pulls out his camera in the last 5 seconds. Don't approach me. I'm telling you not to approach me. Even though he knew I was going to look at the spot where he takes his dog to supposedly piss and shit, which is 20 feet away from his own house.
Okay. All right. Thank you. I'm not going to enter the order in this case. Mr. Matson, Mr. Grover has made it very plain that he does not want you contacting him. And you appearing at the end of his driveway early in the morning with a boombox, like I said, seems to me intentional. So let's not do that. And any beef you have with Mr. Grover, you report it to law enforcement, report it to whomever, but don't report it to Mr. Grover. He doesn't want to hear from you about it. So I strongly urge you not to do that. Mr. Grover, the car, the law requires you to have muffler devices on your car. So if you don't, I'm not going to issue you a ticket.
I mean, if the cops are going to give me a ticket, they're going to give me a ticket. It's my fault,
Okay, well, just know it is aggravating at least one neighbor in your neighborhood, but I'm not making an issue. I'm just putting it out to you.
I know.
All right, so Mr. Matson, you're going to have to ignore it and ignore Mr. Grover.
Thank you, Your Honor.
All right, thank you, Mr. Grover.
Yeah, I just want to make it known. I do plan on doing a FOIA request at his work, so I just want to let you know ahead of time before he tries to, say anything about that. I wanted to let you know because he works for the Washington State Department of Wildlife.
Okay, and I'll let you know that the folks are entitled to call law enforcement as many times as they wish. It's up to law enforcement to decide what to do about it. We never restrict somebody from calling law enforcement or,
Well,
whatever
I
else.
just wanted to let you know beforehand so someone doesn't say I'm harassing them for work. Thank you.
No, you're allowed to make those requests. Thank you both.
No,
you're all done.
Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye. Ms. Donahue. Okay, you don't have service.
No, I don't, but I need to ask again, the court, if they could please, since this is the 5th hearing I've been through, and everyone that's getting protective orders are way lower in concern to mine.
All right, you and I talked about this before. I'm not going to revisit the decision of the judge not to give you an order. All we can talk about is, has Mr. Kovas been served? And the answer is no. And this is Let me make sure I'm correct about this.
This
See,
plea is
one,
regarding human
two.
trafficking.
Yeah, I
rape,
understand.
And video.
Yeah, you told
But
me all
you
about it.
gave a dog
Yeah, you
a
told me
protection
about that.
order.
Okay,
You gave Tilly a protection order.
This is
You've
the-
given these
all
people
right.
protection orders.
so I'm just gonna
For a
dismiss.
property line.
Okay, we're not gonna reset it.
You're not resetting it? Well,
No, I'm
I'm
not.
appealing, so
Okay.
I'm not going away just because you don't like me or whatever.
It's nothing
You
about
just
liking you.
can't.
Okay, this is the fourth hearing where we've
No,
given you
no,
a
no,
chance.
this is the second hearing on Lenny Cavallas. Okay,
You-
just because. of
July
the
20,
campaign
August
smear-
3rd.
No.
Okay,
it
this
was
is the third hearing. I'm
This is
sorry,
the
August.
second.
It's July 20th, August 3rd. Okay, I'm not going to argue with you. And then today being August 17th. So it's a third hearing in which you have had an opportunity.
So the
to try
abuser
to get
gets to
served.
skid away from being served and I lose as the victim. I'm just asking you that question.
If you can get information where you believe you can serve them, you can refile the request for the order. But for now, I can't keep carrying this case because it doesn't look like
Well,
there's
if
any
you would
hope you're
give
going to
me
get
a
them served.
temporary, like you did the dog Tilly.
No, that
or
doesn't
these
change
things-
anything
Yes, it
about
does.
service, not about service.
Yes, it does. Look at
Okay.
the subject
All right, Ms.
here.
Donahue, thank you.
No, the subject here.
I know what the subject is. I heard from you
Just
before.
because Washington State doesn't like me because of my letter or my campaign smear, doesn't give you the right to make your decisions.
All right, thank you.
No, there is no thank you. This is against the law. This isn't even the letter of the law. This isn't even the spirit of the law. What you're doing is illegal. And if anything happens to me, I'm gonna start calling the police and I'm gonna call the FBI and we'll see how far this goes.
Okay, thank you.
I want some documentation you're stopping
I'm
this.
gonna give some to you. Just hold on, let me get it filled out.
So he's allowed to rate me, he's allowed to hear. Do you know what I have on my phone? A videotape of a person setting up a room for human trafficking me, and I caught him because he assumed I was part of the crew. And they said they left it a mess. This is him on the video talking to me. I got a license plate number, I got everything. And I said to him,
And
how's it going?
do you believe he's still in Florida?
I think he runs everywhere he wants to run because apparently he's protected. And Jeremiah Robinson the same. Yeah. And what does it matter where he is? Like, again, you can run a company around the country if you want, especially if you're being protected by the state of Washington. So I know what's going on and I don't appreciate it that I'm not being protected. And I do have that documentation. And I have him jumping in his van and running away.
Okay.
I have so much evidence. When this is all said and done, Judge Buckley.
All right. And Ms. Donahue, if you wait, we'll give you a copy of the document you asked for.
So I just want to make it clear, you're stopping this human trafficking, this video, this game on the internet to try to locate me and talk to me so they can rape me. You're stopping this order. Am I correct?
There was never an order in place.
A plea for an order.
Yeah, I told you I would not revisit the other judge's denial of an order
Why wouldn't you?
because we don't review our own judges' decisions. They make a decision and
you
that's
just
what it
stick to
is.
it?
Yes.
Okay.
All right, thank you.
Yep. You know, Miss Donahue, it didn't get any better. We thought it might get better. I thought maybe she would understand after last time, at least a little bit. I knew she'd be back. I didn't expect it to be quite so soon. I feel like we'll be seeing her again real soon with another refiling. I'm wondering like what do they do if they, is it possible that they say, hey, you can't refile? I don't know. But hey, we got a bunch of setups with Judge Ricke. We got one for the 20th, which is just 3 days away. That's going to be an interesting little case, I think. I really enjoyed a lot of the Judge Middleton that we had out there tonight, especially the quote-unquote stalking case. Man, and Judge Dad, it's just nice to have Judge Dad back. It's horrible to see. You know it hurts Judge Dad to have to send somebody away to jail for 44 days. He does not like doing that. He does not like doing that at all. And guy, why did you have to make him do it? You know, he wouldn't do it if he didn't have to do it. That's just Judge Dad for you. What can I say? You know what else you know what I have to do? I have to say thank you to a lot of people. A whole lot of people. I want to say thank you to Vegas Starlight so much. Thank you so very much for the paws. You gave me blue paws. And they were cool paws. I like those paws. I almost paused the stream for the paws, but then I was like, nah, it's not me. And then Specs comes in. Thank you for understanding and accepting me. We always accept you. Understanding, maybe going a little out there. I'm not sure. Yeah. Miss Good Kitty, thank you so very much. The defendant looks like he's drunk. I kind of agree with you, but like I said in my little text, it was hard for me to tell from that angle. Plus, I see a smaller screen than what you see, probably. I think the guy got what he had coming to him. Hey, Kiernos sent me a little wolf head right there. Here, let me show you. That looks cool. That's kind of, thank you for that, Kiernos. That's awesome. Gave it a little heart and everything there, see? You see there now? You see? Oh man, I'm your lone wolf Oozle. I'm the guy who puts these little compilations together. I do this every single night of the week. Same wolf time, same wolf channel. That is 8 p.m. Central Time, 9 p.m. Eastern Time. Sure is. Every single day of the week. Every single day of the week that court's out there that I can grab. These particular shows are all about the daily case period in the story. And the cautionary tales from the day. You may have seen some of these with Recovery Act. You may have seen some of these with the courtroom files. I was probably hanging out there with you too. But I wanted to bring these because Mama likes watching some of this stuff with us. And the chat is second to none, ladies and gentlemen. Come on by. If you're not watching live, you're missing half the experience. Love y'all. I'm your lone wolf Oozle. I am out. And remember, only you can take a bite out of crime. Bye!